S.P. Nikam sir has started his practice in the year of 1975. He is one of the senior most member of Pune Bar Association. Sir has joined judiciary in the year 1997. He retired at the age of 61. After his retirement, he joined and worked as a director of prosecution till 2007. Sir has wrote a book, How to Prove Omission and Contradiction in Criminal Trials. The important thing is that Sir has donated the entire earning of book to Annadan. Thank you.
मी अध्यक्षांना विनंती करतो की त्यांनी सरांचा सत्कार करावा.
सरांनी जे पुस्तक लिहिलेलं आहे तर सरांच्या इच्छेनुसार आदरणीय के.आर. शाह सर यांच्या हस्ते सदर पुस्तकाचं एक प्राथमिक स्वरूपात वाटप आपण 2 ते 5 ज्युनियर मंडळींना करणार आहोत. तर मी आदरणीय के.आर. शाह सरांना विनंती करतो की सरांच्या पुस्तकाचं वाटप आपण करावं. एक 2 ते 4 जण वरती या. सरांच्या हस्ते आपल्याला पुस्तक स्वीकारायचं. शाह सर, आदरणीय शाह सरांना विनंती करतो व्यासपीठावर यावं.
मी ज्येष्ठ वकील शाह सरांना विनंती करतो की त्यांनी आपल्या बारचे सदस्य स्नेहल मॅडम यांना पुस्तक देऊन सन्मानित करण्यात यावं. कमिटीपासून सुरुवात केली. हो, स्नेहल मॅडम यांना पुस्तक घेण्यासाठी स्टेजवरती यायचं आहे. विनंती करतो की त्यांनी शाह सरांच्या हस्ते आपल्याला एक पुस्तक द्यावं. How to prove omission and contradiction in criminal trial. आज आपल्या कार्यक्रमाला प्रमुख उपस्थित लाभल्याबद्दल ज्येष्ठ वकील के.आर. शाह सर यांचा सत्कार अध्यक्षांनी करावा. के.आर. शाह सर यांचा सत्कार आपल्या बारच्या अध्यक्षांनी करावा अशी मी अध्यक्षांना विनंती करतो. अध्यक्ष प्रत्येक ज्युनियर वकिलांना शहा सर एक आधार आहे. कधीही कोणत्याही वेळेस कोणत्याही केसमध्ये अडचण आल्यास उपलब्ध असणारे आपले ज्येष्ठ विधिज्ञ शहा सर. मी शहा सरांना विनंती करतो की त्यांनी 2 शब्द आपल्याला मार्गदर्शन करावे.
मित्र, या कार्यक्रमाला मी निकम साहेबांच्या मुळे आलो. प्रेसिडेंटनी हा कार्यक्रम घेतला, खूप आनंद वाटला. फक्त मला एक बारीकशी गोष्ट खटकली म्हणून मी आपल्या समोर उभा आहे. मला कल्पना नव्हती की प्रेसिडेंटच्या हस्ते मला शाल दिली जाईल. कारण नव्हतं काहीच, फक्त कारण एवढंच की मी थोडासा सगळ्यांच्या पेक्षा जास्त मोठा आहे असं एवढं वयाने. मला नाही वाटत माझ्यापेक्षा इथे बारामध्ये माझ्यापेक्षा वरिष्ठ असे कोण वयाने असलेले असतात. त्यामुळे म्हणजे सत्कार करायचा जर असता तर मी त्यांना सांगितलं असतं की वेगळा एक कार्यक्रम करू आणि त्या कार्यक्रमात माझा सत्कार करावा म्हणून. मला आवडतं अनेक वेळा कोण लोकांनी माझा सत्कार करावा म्हणून. कारण मी फार जेव्हा लहान होतो तेव्हा माझ्या घरातल्या लोकांनी सांगितलं हा तू लवकर मरणार म्हणून. पण मी सगळ्यांना मेलेलं पाहिलं, अजून मी जिवंत आहे. ठीक आहे, आणि मी 100 गाठणार. अरे ज्याने 87, 88 आणखी 4 दिवसांना 88 चालू होईल आणि 4 दिवसानंतर बरोबर 88 वर्ष माझं चालू होईल. 88 पासून 100 किती? 10-12 वर्ष. 12 मॅथमॅटिक्स परमेश्वराचं मॅथमॅटिक्स चुकलं तर आपण त्याला करेक्ट करू त्याला आणि सांगू अजून 2 वर्ष राहू देत, काय फरक पडतो. त्यामुळं या कार्यक्रमाचा हा भाग सोडून द्या. पण मी मनापासून मी सांगतो की राम हे माझे प्रेसिडेंट आहेत. पुन्हा भारतचे प्रेसिडेंट आहेतच, पण हे माझे प्रेसिडेंट आहेत. त्यांना चुकून म्हणण्यापेक्षा त्यांना मी विनंती म्हणून त्यांना माझ्या घरी आले होते त्यावेळी मी त्यांना म्हटलं की आयुष्यातलं 1 वर्ष भारतासाठी काढावं. आणि त्याने मग लगेच ताबडतोब मनावर घेतलं आणि यावर्षी भारतीय प्रेसिडेंट म्हणून आले. स्वभावाने फार चांगला मनुष्य आहे. ज्यांच्या सहवासात येईल ते सर्व माणसं श्रीमंत होतील याच्याबद्दल निर्विवाद आहे. राम यांच्या कर्तृत्वाला आणि या संबंध वर्षाला माझ्या मनापासूनच्या शुभेच्छा आहेत. कशाला पाहिजे?
आजचे प्रमुख वक्ते निकम सर यांना विनंती करतो की त्यांनी आपलं मार्गदर्शन करावं.
आपल्या सर्वांचे गुरुजन आदरणीय के.आर. शहा, पुणे बारचे अध्यक्ष रामभाऊ भुजबळ, पुणे बारचे सर्व पदाधिकारी, सर्व सिनियर ॲडव्होकेट्स आणि ज्युनियर कलिग्स, 200 पुस्तकं वाटायला दिलेली आहेत. सर्वांना पोचली का? Now, with your permission, I will proceed with the subject. The subject is how to prove omissions and contradictions in the criminal trial. You are aware that there are several defenses in the criminal trial. For example, the accused will say, I have not committed an offense and I am falsely implicated in the case. The second type of defense, it may be alibi, that at the time of commission of the offense I was somewhere else. It may be the right of private defense, and so many defenses there are in the criminal trial. But whenever there is no defense available, the proof of contradiction and omissions is the best defense, best weapon available in the hands of the defense counsel. So, sometimes it happens that there is no defense, and therefore we are required to use the weapon, that is the proof of omissions and contradictions in the criminal trial, in order to get the acquittal of the accused. Now, the contradiction and omission. The contradictions are of two types. One is the direct contradiction and other is the contradiction by way of omissions. So, what is the omission? The witness is in the witness box. He is deposing before the court. He is narrating the story before the court, and it is expected that he should narrate the story before the court as per his statement recorded under section 161 CRPC. Now, friends, I will refer henceforth the provisions of Criminal Procedure Code and Evidence Act, and not the latest law, because I am unaware of the numbering of the latest law. Now, regarding the omissions and contradictions, the provision regarding contradiction is given in section 162 of the Criminal Procedure Code. Likewise, the previous statement of the witness is required to be contradicted, and the mode of contradicting the previous statement of the witness is given under section 145 of Evidence Act. So, in order to prove the omissions and contradictions, what is required? Before going into the exact example, to contradict means treating it adversely. The omission means to omit to state before the court whatever the statement of the witness has been recorded under section 161 CRPC. You are aware that whenever offense is committed, the FIR is lodged under section 151 CRPC. After lodging FIR, the CR is registered and investigation has been started. During course of investigation, the IO is recording several panchanamas. He is seizing the Muddemal property articles, and it is also one of the part of the investigation that he has to record the statements of the witnesses under section 161 of the Criminal Procedure Code. Now, this statement, it has certain limitations. said statement cannot be signed by the witness. So, the statement of the witness which has been recorded during course of investigation is not signed by the witness. Now, such type of statements are before the court. The copy of the such statement is given to the accused, and defense counsel is also having that copy. However, such type of statements which are recorded under section 161 CRPC cannot be used by the court as evidence. That means the court is not permitted to read the statement in evidence. Why? Because there is a bar which has been laid down under section 162 of the Criminal Procedure Code. Section 162 Criminal Procedure Code says the statement which has been recorded under section 161 CRPC is to be used only to contradict, and therefore the prosecution is also not permitted to read the statement. The court is also not permitted to read the statement in evidence. Only the accused, that is the defense counsel, can use the statement to the limited extent of contradicting the said witness. So, now for example, I am giving a fact of one of the case that there are two accused. Accused A and accused B. It is the prosecution story that both accused abused, and accused number 1 inflicted stick blow, and according to the statement of the said witness has been recorded under section 161. Now that statement is before the court. That witness is in the witness box. So what is the case? That accused A inflicted stick blow. Now the witness in the witness box has deposed before the court for the first time that accused B inflicted stick blow. Now, what is omission now? Witness has stated for the first time before the court that accused B inflicted stick blow. His statement regarding accused B is omitted before the IO when he recorded statement under section 161 CRPC. That means the overt act of accused B, the role played by accused B, has been omitted by this statement to depose before the court. This is called the omission. He has omitted to state, because what he has stated before the police while recording his statement, accused A inflicted stick blow. Now first, for the first time in the witness box, he is deposing that accused B inflicted stick blow. Now role played by accused B is omitted in the statement before the police, and therefore this is omission. So what is omission? In simple words, omission means omitted to state before the police, and for the first time deposing before the court which is not stated before the police. Now again we will come to the facts of the case. The witness has stated before the police that accused A has inflicted stick blow, and now before the court, during course of examination in chief, he has stated that accused B inflicted stick blow, and this is the omission. Now this omission is required to be proved, and Thereafter, you are required to argue before the court regarding getting acquittal regarding accused A and B. Being a defense counsel, it is your duty to get the acquittal regarding accused A and B. And simultaneously we will argue accordingly. And we will succeed regarding getting the acquittal regarding both accused. Now, the witness has stated for the first time before the court in the witness box, which is not stated before the police. Now his police statement is to be contradicted, and that is the procedure is laid down under section 145 of Evidence Act, that how to contradict the previous statement. The previous statement is now contradicted, and it should be contradicted in the given questionnaire. So what is that questionnaire? For the first time, the defense counsel must ask the question to the witness that now you are stating that accused B inflicted stick blow. Now, in order to contradict, you must ask the question to this witness that you have just now deposed before the court that accused B inflicted stick blow. Whether you have stated accordingly while recording your statement before the police. The witness will say, yes, I have stated before the police when my statement was recorded that accused B inflicted stick blow. I have stated accordingly. Thereafter, your further question should be that I am drawing your attention to your statement before the police, and simultaneously you should request the court that the attention of this witness has been drawn towards his statement, recitals of the statement recorded during course of investigation under section 161 CRPC. I am very sorry that I am also now 79 age, and that is why I used to drink it. Now, attention of the witness is drawn towards his statement before the police. Now, see, this is your statement recorded by IO, and whether you have stated before the police that accused B inflicted stick blow, you ask this question. He will say, I have stated before the police. Now, this is your statement. Now, an opportunity to explain is also required to be given. If the opportunity to explain is not given, remember two things regarding proof of the contradiction and omissions. The attention of the witness towards the recitals of his statement, one thing. And second, an opportunity to explain is required to be given. If an opportunity to explain is not given, the contradiction is not proved. Therefore, this procedure must be followed, is required to be followed. Now, you have shown the statement before the police. You ask the further question. This is your statement. It is your case that I have stated before the police that I saw accused B inflicted stick blow. This your statement does not find place in your statement before the police. Can you explain why it does not appear in your statement before the police? This opportunity must be given to the witness. So, he will say, Now what is our question? It is your case that you have stated before the police while recording your statement that you saw accused be inflicted stick blow. This statement does not find place in your statement before police. Can you explain? He will say, I can't explain. Now, your further question, that even though you are saying now that you have stated before the police that I saw accused be inflicted stick blow, you have not stated accordingly before the police. Again he will say, no, I have stated accordingly. Now, here one denial is required because there is a substantive evidence against the accused B that witness has stated before the court that I saw accused B inflicted stick blow. That means there is a substantive evidence against accused B, and therefore denial is required to be given. That you have just now deposed that you saw accused B inflicted stick blow is a false. Now you are required to stop your cross-examination of that witness. And when I was in the witness box, asked two questions to IO in order to prove that particular omission. You should ask the IO whether you have recorded the statement of this particular witness on such and such date. IO will answer positively, yes, I have recorded the statement of this witness on such and such date. You ask the further question, whether this witness has stated before you that this witness saw accused B inflicted stick blow. IO will reply, no, he has not stated before me that accused B inflicted stick blow, and now this omission is proved. Now, all omissions are not contradictions. Even you are required to prove the contradictions. All omissions are not contradictions. Only omissions on the material point are the contradictions. The incident is the material point. Now, for example, if witness said, yesterday I came from Bombay by motor car, that is in the statement before the police, and today this witness deposed before the court, yesterday I came from Mumbai by ST bus. ST bus is an omission. It is not required to be proved because it is not a contradiction, because it is not on the material point of incident. Whether that witness yesterday came by bus, ST bus, or by motor car, or by aeroplane, that is totally immaterial. It will not assist you, and therefore only omissions on the material point are the contradictions, and those are required to be proved. Now why? Why omissions are required to be proved? That I will come later on. Before that, we will argue on the given or proved contradiction just now before the court. Your Honor, I am arguing regarding accused A and B. Both accused be acquitted. Regarding accused A, I am arguing just now. This witness has not stated anything in the substantive evidence regarding accused A. Absolutely there is no evidence, no oral evidence regarding accused A before the court. And therefore, if there is no substantive evidence before the court regarding accused B, that accused is required to be acquitted. And accordingly, we will get the acquittal regarding accused B. Now we will argue regarding acquittal of accused B. Your Honor, there is a contradiction. And whenever there are contradictions, then such witness should not be believed by the court. The testimony of such witness is required to be discarded in toto. And if the witness is not believed, in that event, it is necessary to acquit the accused. So you may argue before the court, Your Honor, this witness is stating something else before the police and something else before the court. Which story is to be believed? Therefore, this witness is not worthy to be relied upon, and therefore, he has not established anything regarding accused B also, because for the first time he has deposed before the court regarding role played by B. He has not stated anything before the police, and the contradiction has been proved, and therefore I am entitled to get the acquittal regarding accused B. So, now you would have been realized the contradiction is a very important weapon in the hands of the defense counsel. Contradiction, proof of contradictions means what? What is the meaning of that? The proof of contradiction, we have just now stated that it is the good weapon in the hands of the defense counsel. The proof of contradiction is nothing but impeaching the creditability of the witness. Because by proof of contradiction, we are impeaching the credit of the witness. Now, what we have impeached just now, this witness has stated something else before the court and something else before the police. Therefore, he has given two versions, different versions. One is regarding accused B, other is regarding accused B A. Which version is to be believed? Such type of witnesses are not worthy to be relied upon. The testimony of such witness should be discarded in toto. And if the witness is disbelieved by the court, that accused is required to be acquitted. So, mode of the proof of the contradiction is nothing but discrediting the credit of the witness. Now, you are aware, sometimes in order to discredit the witness, we are giving several suggestions to the witnesses. That one of the suggestions that you are having enmity with the accused, or you are friend of the complainant, you are having the enmity of the accused, and that is why you are deposing falsely before the court. So, one of the ground is enmity. Sometimes we are giving suggestion to the witnesses that you are bribed by the complainant, and that is why you are deposing before the court on behalf of the complainant and favorable to the complainant. So, these are the one of the grounds of impeaching the creditability of the witness. Proof of the contradiction is nothing but impeaching the creditability of the witness. And if the credit of the witness is impeached, and if the court is satisfied that his credit has been impeached, this witness is not having any credit to rely upon his testimony. His testimony is not at all, that way, in order to prove better against the accused. And accused cannot be convicted relying upon such type of witnesses. Now, regarding contradictions. The contradictions can be proved by the defense counsel. Likewise, the contradictions can be proved by the prosecution also. By the prosecution, how contradictions are to be proved? You are aware that sometimes the witness is not supporting the prosecution. Even though his statement is before the court, he has supported the prosecution while recording his statement. But when witness is in the witness box and prosecutor is recording his examination in chief, that witness is not supporting the prosecution version. And for that purpose, such witness is required to be contradicted, and for that purpose you are required to two things. In order to contradict that witness, his own witness, Section 154 Evidence Act is required to be taken into consideration, because Section 154 Evidence Act says the party calling his own witness also can be cross-examined, but for that purpose, only provision that you must seek the permission of the court. Unless and until permission of the court is not given, the prosecutor is not permitted to cross-examination his own witness. So under Section 154, the prosecution is permitted to cross-examine the witness, his own witness, and then prosecutor will bring on it record that this witness has stated before the police, that is the version favorable to the prosecution, and now this witness is hostile. And now he will note the portion marked A, portion marked B, and accordingly he will give the exhibits to the portion mark and argue before the court, Your Honor, this witness has been declared hostile, he has resided from his version, and this is his statement before the police, has been proved, that is portion marked A, B, C, and that portion mark is also can be exhibited also. Now, on the proof of omissions and contradictions, there is only one authority on the subject, and that is reported in AIR 1959 Supreme Court, that is Tahsildar Singh versus State of Uttar Pradesh. That is the only leading case on the subject. That is the judgment of 6 judges of the Supreme Court. That judgment has been delivered separately. And when we are reading that judgment, when I was going through I was reading that judgment, I never followed that judgment initially. When I was acquainted with the facts, and thereafter I read that judgment second time, still I never understood what is that judgment. When I noted the contradictions and omissions, and then third time I have gone through the said judgment, and then I understood what is that judgment. That is the leading judgment of the subject, that is the proof of the omissions and contradictions. Now, this is regarding the omissions and contradictions regarding the witnesses. What about the complainant? Because the statement of the complainant is not recorded, because he has recorded FIR. Whether FIR can be contradicted. We have noted that in a statement under Section 161 CRPC, there is no signature of the witness. But on FIR, the complainant has signed it. There is a signature of the complainant on the FIR. Now, you are aware that the statement under Section 161 CRPC cannot be exhibited. The FIR is to be exhibited. after during course of examination of the witness, that is the complainant, he has stated before the court that I have lodged this FIR, it bears my signature, the contents are true and correct, and thereafter FIR will be exhibited. Now, when the FIR is exhibited, we can read that document in evidence. We just have gone through that the court is not permitted to read the statement under section 161 CRPC in evidence. There is one exception. Court can read the statement under section 161 CRPC for the purpose of bail, for the purpose of inquiry, but not for the purpose of trial. Now, here regarding the FIR, the case is entirely different. The document before the court is, being FIR, is an exhibited document. It can be read in evidence by the court. Therefore, when we are reading the contents of the FIR before the court, the proof of omissions and contradictions is required. The answer is still yes. I have gone through. There are several judges in the Maharashtra. When the defense counsel is, in order to prove the omissions in the FIR, the judge will say, no, we will read the FIR and we will find out the contents therein and we will trace out the omissions and contradictions. This view is not correct, because just now we learned two things are required in order to prove contradictions. One, attention of the witness must be drawn to his statement. And secondly, an opportunity to explain must be given. If we are reading the statement of the witness, complainant before the court, examination chief, and the contents of FIR, we need not find out the contradictions, because in such type of procedure, we have not given an opportunity to the witness to explain. We have not given an opportunity to the complainant to explain why you are not stated before the police when your FIR was recorded. And therefore, the view which some of the judges are having, that in order to prove the omissions and contradictions in the FIR, as FIR is exhibited document, we need not prove the omissions and contradictions by way just now we adopted it. So, in order to prove the omissions and contradictions in the FIR, same mode is required, because we have to give attention of the witness towards his statement, that is towards his contents of FIR. One thing. And secondly, an opportunity to say, an opportunity to explain. Now you are saying before the court that accused be in preteristic blow, but in your FIR, it is mentioned that accused is in preteristic blow. Can you explain? So an opportunity to explain is required, and therefore the mode of proof in order to regarding the contradictions, same mode is required in order to prove the omissions and contradictions in the FIR also. Now, the the omissions and contradictions. At what time they are to be proved, because there are several types of examinations of the witnesses. You are aware there is one type of examination of witness, that is called examination in chief. The second type is the cross examination, which comes after examination in chief. And third is the re-examination, only to explain certain things which occurred during course of cross-examination. And there is also another mode of cross-examination, perhaps which is not given anywhere, but the occasion comes. Examination in chief, cross-examination, re-examination, and the fourth mode is cross-examination after cross-examination. Where is that mode? How it is available? I will give the example. When that occasion occurs, cross-examination after cross-examination. Now, what witness is in the witness box? During course of examination in chief, he has stated everything as per prosecution version. All things. So he was stick up during course of examination chief to the entire prosecution story. He was cross-examined by the defense counsel. During course of cross-examination, during the course of cross-examination, he has replied favorable to the defense. He has replied everything favorable to the defense. Remember, in the examination chief, stated favorable to the prosecution. During course of cross-examination, such type of occasion occurs very rarely. During course of cross-examination, even though he was not declared hostile, he has given during course of cross-examination, he has given reply favorable to the defense and contrary to the prosecution version. Now, in such type of cases, the occasion occurs to the prosecution to cross-examination that witness, which is called the cross-examination after cross-examination. For that purpose, the permission of the court is a must. By declaring said witness hostile, you are required to submit before the court that this witness has supported the prosecution version during course of examination in chief. He resigned from the prosecution version during course of cross-examination, and he has given all the admissions regarding defense counsel or regarding the accused, and he has damaged the entire prosecution case, entire prosecution version, and therefore such type of witness is required to be cross-examined after the cross-examination of the defense counsel, and this type of cross-examination is to be conducted by the prosecution. And while conducting such type of cross-examination, perhaps the question again arises: if he is complainant, you are required to refer the contents, the recitals of the FIR in order to prove the contradictions. If the said witness is the witness and his statement has been recorded under section 161 CRPC, you are required to bring the attention of the witness towards his statement recorded during course of investigation under section 161 CRPC. So same mode. So the cross-examination, after cross-examination, question arises very rarely. In very rare cases, it happens sometimes the witnesses are very clever. They are supporting the prosecution and they are also supporting the defense counsel during course of cross-examination. So, in my book, you will find that I have given the questionnaire and one example is given. I have given one the format 1, that is on page number 13. I have given the format. This is very useful for while reading. In order to study it, on page number 13, I have given format 1, and this is the statement of the witness recorded during course of investigation. And in this case, he has stated that he came from Pune by ST bus. And the contradiction is regarding the name. There are two accused in this case, Suresh and Baban. The case is Baban has inflicted stick blow. Now he has stated Suresh. On page number 14, that is the format 2. Format 2 is the examination chief of this witness. And in the examination chief, he says, on 1st of December 2017, I returned from Pune by car. And in police, before police, he has stated, I returned by ST bus. So now he is deposing before the court, I returned from Pune by car. This is omission, but it is not a contradiction, because it is not on a material point. So we need not waste the time of the court in order to prove such type of omissions which are not at all contradictions. Now, second main contradiction is that accused Baban inflicted stick blow. So, he has stated that accused Baban inflicted stick blow. He has deposed before the court for the first time the name of Baban. And before the police, he has stated that Suresh has inflicted stick blow. So, role played by Baban, he has deposed first time before the court, even though it was not the case of the prosecution. Now, on page number 16, there is a third format. On page number 16, there is the third format. That is the cross-examination on behalf of accused. And in this format, I have given the questionnaire in order to prove the omissions and contradictions. You are required to take the cross-examination of the witness in the given format. You will not find this format anywhere in any book. So, you are required to follow this format, and after, just I will read. Did it happen that you did not see Baban inflict a stick blow on person of Bunty? He said, no, I did see accused Baban inflict a stick blow on person of Bunty. Then second question, is it true that police recorded your statement during course of investigation on such and such date? He will say yes. You did not tell police that you saw accused Baban inflict a stick blow on person of Bunty. He said again, I did tell. I told accordingly before the police. And now his attention of the witness is drawn towards his statement before the police. And now the question number 5 is very important. Can you explain why statement is not found in your statement before the police? Now, opportunity to explain is required to be given. If this opportunity is not given, the contradiction is not proved. So, these are the 3 formats. And in this one example, on page number 13, here I have given 3 omissions. One is regarding ST bus, second is regarding Suresh, and third is regarding injury. Before police has stated injury sustained on the right hand, and in the court he has stated I sustained injury on the left hand. So, suspension of injury on the left hand, it is also a contradiction because it is regarding the incident. Regarding accused Baban and Suresh, it is regarding incident, it is also contradiction. But the first is not a contradiction, it is merely omission that yesterday I came from Pune by ST bus. Is merely omission and does not amount to a contradiction. So, I have given these 3 formats and the questionnaire, and in the light of this questionnaire, we are required to prove, and again the format 4 is given, and that format 4 is on page number 19. And that is the regarding the direct contradictions, that is the without any omissions, that is given. And again on page number 22, I have given the contradictions regarding the prosecution, how prosecution has to prove the contradictions. So, in short, question is very small. Provisions, only few provisions are required to be followed. Section 161 CRPC, Section 145 of Evidence Act, and Section 155 of Evidence Act, impeaching the credibility of the witness. So, only these 3 sections are covering this portion. Very small, but sometimes it is very useful whenever you do not have any defense. On the basis of the omissions and contradictions, you can point out and argue before the court that this witness deposing falsely and this witness is not worthy to be relied upon. The testimony of such witness, accused cannot be convicted relying upon such type of witnesses, and therefore it is necessary to get the acquittal. So, friends, even though it is a very small question, this for your exercise purposes at your home, you may go through and solve 2-3 problems here given, and if you will solve these 2-3 problems, you will not forget any time such type of proof of the omissions and contradictions. So, for giving patiently hearing, I am very thankful of you all, and in very shortly time, I am completing this small lecture. Thank you very much.
खूप खूप धन्यवाद सर. यानंतर आपल्या कार्यक्रमाचे अध्यक्ष प्रमुख जिल्हा सरकारी वकील यांना मी विनंती करतो की त्यांनी आपल्याला मार्गदर्शन करावं.
मंचावर उपस्थित असलेले पुणे बारचे अध्यक्ष रामभाऊ भुजबळ, त्यांची कार्यकारिणी, त्याचप्रमाणे मंचासमोरील सर्व सिनियर वकील मंडळी, त्याचप्रमाणे माझे ज्युनियर मित्र, आज आपण हाऊ टू प्रूव्ह ओमिशन अँड कॉन्ट्राडिक्शन इन क्रिमिनल ट्रायल याबाबत SP निकम सरांचं लेक्चर जे आहे ते ऐकलं. त्याचप्रमाणे त्यांनी काही सायटेशन पण दिलेले आहेत या पुस्तकामध्ये. त्याचा पण उपयोग जो आहे तो आपल्याला डेली प्रॅक्टिसमध्ये जो आहे तो होणार आहे. त्याचप्रमाणे दुसरी महत्त्वाची बाब अशी आहे की एक सायटेशन आहे 1964चं दायाभाई ठक्कर वर्सेस स्टेट ऑफ गुजरात. त्याच्यामध्ये सरांनी जे सांगितलेलं होतं की चीफ एक्झामिनेशनमध्ये फुल सपोर्ट केलेला होता प्रॉसिक्युशनला, पण क्रॉस एक्झामिनेशनमध्ये जर त्या विटनेसनी डिफेन्सला मदत केली असेल तर परमिशन जी आहे ती मिळते प्रॉसिक्युशनला. त्याबाबत हे लँडमार्क जजमेंट आहे 1964चं दायाभाई ठक्कर वर्सेस स्टेट ऑफ गुजरात. दुसरी महत्त्वाची बाब अशी आहे की सर्वप्रथम तर मी आपली जी कमिटी निवडून आलेली आहे त्यांचं अभिनंदन करेल आणि या टेन्युअरमध्ये, त्यांच्या 1 वर्षाच्या टेन्युअरमध्ये त्यांनी जास्तीत जास्त चांगले लेक्चर्स, त्याचप्रमाणे नवीन ज्युनियर वकिलांना हेल्पफुल ठरतील असे विषय जे आहेत ते घ्यावेत. त्याचप्रमाणे याआधी पुणे बारच्या वतीने, त्याचप्रमाणे अधिवक्ता परिषदेच्या वतीने स्टडी सर्कल जे आहेत ते घेण्यात येत होतं. ती परंपरा जी आहे ती रामभाऊ भुजबळ यापुढे सुरू ठेवतील अशी मला आशा आहे आणि मी माझे 2 शब्द संपवतो. धन्यवाद.
खूप खूप धन्यवाद सर. आजच्या कार्यक्रमाचे आभार प्रदर्शन मानण्यासाठी मी आपल्या बारचे पदाधिकारी आणि आजचे बड्डे बॉय त्यांच्या अगोदर मी आजच्या कार्यक्रमाचे आभार मानण्यासाठी मी आपले ऑडिटर आणि ज्यांचा आज वाढदिवस आहे असे शिवराज निंबाळकर सर, मी यांना विनंती करतो की त्यांनी आजच्या कार्यक्रमाचे आभार प्रदर्शन करावे.
आदरणीय व्यासपीठावर उपस्थित आजचे कार्यक्रमाचे अध्यक्ष DGP बटकर सर, कार्यक्रमाचे प्रमुख पाहुणे SP निकम सर, ज्यांनी उत्कृष्टपणे असं वास्तविक उदाहरणे देऊन चांगलं असं लेक्चर आज पार पाडलं आणि आपल्या सर्वांनी मोठ्या संख्येने उपस्थिती लावून या कार्यक्रमाची शोभा वाढवली आणि अशीच उपस्थिती राहिली तर कमिटी चांगले कार्यक्रम यापुढेही घेत राहील. आणि विशेष म्हणजे सिनियर ॲडव्होकेट्स इथे भरपूर उपस्थित आहेत, त्यांचं मी विशेष आभार मानतो आणि प्रमुख पाहुण्यांचं आणि अध्यक्षांचं मी आभार मानतो आणि त्यांची परवानगी घेऊन कार्यक्रम समाप्त झाला असं मी जाहीर करतो.
हो आहे, जेवढे आहे तेवढे दिले, जेवढे आहे तेवढे दिले.